easier today because it's gray out as opposed to yesterday. It's a pleasure to introduce our next speaker on the Interpretability in Law session. Rebecca Wexler is an assistant professor of law and faculty co-director of the Berkeley Center for Law and Technology at UC Berkeley School of Law. She works on data, technology, and secrecy in the criminal legal system, and her real focus has been on legal doctrines that limit criminal defense counsel's ability to scrutinize machine learning systems and other new technologies that law enforcement use to generate and analyze evidence in criminal cases. Rebecca also has, her work is very grounded because she herself was a public defender for many years. And so she brings some, I think, very important real world credibility and information into our discussions. And with that, I'm going to invite Rebecca to take it away.
Okay, thank you so much, Deirdre. Thanks to everyone for coming. I'm thrilled to be here. As Deirdre said, I work on data and technology and secrecy in the criminal legal system. So I'm going to start the talk by giving a brief overview of how these technologies are coming into the system and what the legal adversarial process looks like or should look like. And then I'm going to talk about 4 buckets of legal doctrines that can block access to information that might be helpful for interpretability in machine learning systems. So to start, I tested this and now it works. To start, what is the adversarial criminal legal system? Well, in the US, we rely on law enforcement, that's police and prosecutors, to investigate evidence of guilt and present that to the jury. And we rely on criminal defense counsel to investigate evidence of innocence and present that to the jury, as well as to scrutinize, contest, challenge, probe, question the prosecution's evidence of guilt. So this is very important to realize that law enforcement has 0 constitutional, statutory, or ethical obligation to investigate evidence of innocence. And if there are flaws in law enforcement's evidence of guilt that the police and prosecutors don't know about, they also have 0 duty to disclose that information to the defense. So the entire system relies on defense counsel to surface flaws, biases, errors, fraud, inaccuracy, unreliability in prosecution evidence. And that is why we need something called criminal subpoenas. And this is the process that a defense counsel would use to try to access information about a machine learning system, the outputs of which are being used in their case against their clients. Actually, I'm realizing I should give a little bit of a background on what kind of systems this might be. This could be predictive policing systems that a defendant might challenge as biased or violating of the Equal Protection Clause. This could be a face recognition or voice identification systems that police rely on the outputs for investigations to search and seize, to arrest somebody, or ultimately also to introduce those outputs as evidence of guilt at the trial phase of a case. So those are a couple of examples, but then later on in the process, you might have risk assessment instruments that are used to decide whether somebody gets pretrial incarceration or sentencing, used to guide sentencing. And there's a slew of other kinds of technologies you could imagine, machine learning and not machine learning, the outputs of which could be introduced to search, seize, arrest, or convict or sentence. So criminal defendants are going to want to test and scrutinize those systems, and they're going to use this thing called a subpoena. The subpoena is going to let them demand information from the developer of the system. Okay, so demand information that law enforcement might not have, demand source code, training data, input weights for models, user manuals, specifications, anything you might want to know about a system, you're going to use this subpoena power to get at the third-party developer and try to compel disclosure of information. Now, another piece of important background information here is that this power to compel disclosure is actually pretty minimal. So it requires these things that you can only access information that's relevant, you can only access information that's going to be admissible in your case, and you have to identify the information with specificity. So if you're hearing this process and you're a developer of machine learning systems that you sell to the criminal legal system and you're getting really worried that defense counsel might go on a fishing expedition and try to exploit you to disclose irrelevant stuff just to raise the costs or create problems for you, this is going to tamper down what defense can get at any baseline level. On top of that, there are doctrines called privileges. And privileges add extra secrecy protections that can be used to block these defense subpoenas. And I'm going to spend the rest of the talk talking about privileges, okay? But from the big picture, you could see we want privileges to be pretty narrow because they are very costly. They interfere with the truth-seeking process of the criminal legal system by suppressing evidence that would be relevant, that would be admissible, and that is identified with specificity in that subpoena. Even though you satisfy all those things, if there's a privilege, a special secrecy power, developer can quash it. All right, now my 4 buckets of secrecy powers. The first one is trade secret law. So trade secret law is a form of intellectual property. It is a protection for information that's commercially valuable, that's also not generally known in the industry. So it's got to be secret, protected by reasonable confidentiality measures, and to have economic value by virtue of that secrecy. Criminal defendants have been denied access to an array of information about automated systems, some with machine learning, some without, based on developers claiming that the information that defendants seek is a trade secret. Okay, so source code, again, user manuals even, they were denied based on trade secret arguments. This doctrine of using trade secret law to block criminal defense access to information is actually relatively recent. There are privilege protections for trade secrets in civil cases that often arise in patent disputes and other contract disputes where trade secrets are at stake in trade secret misappropriation suits. And what usually happens in those civil cases is that the information is disclosed to the opposing counsel under a strict protective order, to the opposing expert witness under a strict protective order that says, don't share this with your client, only use it for purposes of this case, don't go publish a thing on the internet. And if you do, we're coming after you for contempt of court, breach of contract, ethical violations will get you disbarred, all of those things. But in the criminal legal system, developers have actually asserted an even more powerful right to withhold information. And they've done this in part, I believe, because criminal defense counsel are not very well equipped to challenge their trade secret claims. And so you have a huge disparity of power between the developer's lawyers and the defense counsel's lawyers. And the result is a high risk of overclaiming of secrecy protections when it's not actually necessary to protect the developer's economic interests. The information could be being disclosed to defense counsel under a protective order as it is in civil cases. And instead we're seeing developers successfully entirely withhold information that would be relevant to the criminal defendant's case. I started working on that issue a number of years ago, and there has been some positive reform. In my view, I think the secrecy power should be limited. So there have been state laws passed that preclude developers of risk assessment instruments, this is in Idaho, from claiming trade secrets about those systems to bar defense access to information. There have been a couple of bills presented in the United States Congress, and in the courts, defendants have been able to get some headway in defeating this trade secret privilege, which I think is a good thing. The fight has shifted a little bit now to the scope of protective orders. All right, my second bucket of legal doctrines that can block access to information you might want for interpretable machine learning is privacy. So privacy, lots of people are supportive of privacy. Privacy is generally something we care a lot about. There's some privacy legislation pending in the federal level. Hope that gets passed. But let me tell you a story about some of the downsides of privacy. This is a case from a former colleague of mine at the Legal Aid Society of New York City. Police in New York City jailed a man, we'll call him John Doe, for allegedly violating a family court protective order. The alleged victim showed police screenshots of harassing text messages and recordings of harassing voicemails, whispering texts that she claimed John Doe had sent to her. And neither the police nor the prosecution questioned the authenticity of those screenshots or audio recordings. Hence, they used this to jail the man pre-trial. Somebody jailed pre-trial, very likely that they will confess, plead guilty in order to go home. The consequences of being pre-trial incarcerated, you could lose your job, you can't get in touch with your kids, you can lose your housing, very high penalty. In this case, this man refused to plead guilty. He claimed innocence, and he told defense counsel, my former colleague, that he did not send those text messages, he did not send the voicemails. And so counsel took a random chance and subpoenaed a company called Spoof Card that provides commercial spoofing services where you can send a message that appears to come from somebody else's phone number. And lo and behold, this company disclosed records. This is an actual screenshot of the actual records from the case, redacted, establishing that the alleged victim had a paid customer account and that she had used it to disguise those messages and sent the messages to herself, sent the voicemail to herself using a voice changing software to make it sound like a man. And so this case shows why criminal defense subpoenas matter so much. This was exonerating, completely exculpating evidence, an innocent man wrongfully jailed. The government would never have gotten this evidence because it believed the alleged victim. And crucially, the only way that defense counsel could get it is that they could subpoena a private company for somebody else's private records. This was not a subpoena for the client's own records. It was a subpoena for the alleged victim's records. Okay, in a case like that, defense subpoenas to private companies could be the only means to exonerate somebody who's wrongfully convicted. Now, here comes the bad part. Unfortunately, many privacy statutes block precisely this type of defense subpoena, okay? Privacy laws passed by well-meaning legislatures sometimes include blanket non-disclosure provisions. They say, hey, company, you've got sensitive information. You're not allowed to reveal it. And then they have an exception. They'll have an exception for law enforcement because law enforcement has a powerful lobby. And it goes to the legislature, it says, give me an exception, and they do. Nobody or few people go to the legislature and say, give criminal defendants an exception. So there's a pattern in privacy laws that systematically advantages law enforcement investigations of guilt as compared to criminal defense investigations of innocence. And I call these privacy asymmetries. So privacy laws that permit courts to order disclosure if law enforcement asks for evidence, but not if criminal defense counsel asks. There's a couple ways that I think these asymmetries are exacerbated by new machine learning systems. So one is if only the government gets to access data dumps from social media accounts, for instance, or gets to search biometric databases, only the government gets to benefit from new machine learning search tools like image recognition or DNA analysis software run against familial DNA databases. So one is, who gets to deploy new machine learning systems? Okay, if you can't access the data, the deploying of machine learning systems using data isn't going to be very helpful to you. Similar, access to training data. If you wanted access to training data to scrutinize machine learning systems, you could run into this asymmetry. And finally, developing machine learning systems. If you need data to develop new systems and only law enforcement can access data, only law enforcement's going to develop the systems. So, all right, happy to talk a little bit more about those later if you're interested, but here's a list. Oh, I think you can't even see all of them, but here's a list of a series of federal statutes that I identified that have these privacy asymmetries. So it's a repeat problem. Bucket number 3 of legal barriers to accessing information you might need for interpretable machine learning is the law enforcement privilege. So IP laws we talked about, they protect information for commercial, economic reasons. Privacy laws protect information for dignitary, autonomy reasons, other reasons. This is a doctrine that protects information for security reasons. In the domestic law enforcement context, police sometimes say, we're going to use this investigative method and we need to keep it secret, even while we rely on the outputs to arrest somebody or convict them at trial. We need to keep it secret because if it became generally known, people committing crimes could evade detection. So everybody knows where I put my surveillance camera. They're going to tamper with it, destroy it, avoid it, whatever. Everybody knows, how my remote computer hacking tool exploits a vulnerability in a network or a device. Well, that vulnerability is going to get patched and the exploit's going to go away and the investigative method's going to be ineffective at scale instantaneously. So they say to the courts, I'm going to use this method. I'm going to use the outputs. I'm going to introduce the outputs into evidence in court, but I'm not going to tell you anything about the method. Well, that's a problem, or I'm not going to tell you, I should say, everything about the method. That's a problem because defense counsel might want to know, was that method unconstitutional? Was that method unlawful? Was it far more privacy invasive than law enforcement claims? Or perhaps was it less accurate, less reliable than law enforcement claims? And there's a risk that law enforcement might be mistaken in their assertions about how these things work. They might be exaggerated in their assertions about how valuable secrecy is to security, or they might be making pretextual claims to conceal wrongdoing or negligence. They might even be perpetrating fraud on the court. How is defense counsel going to know? So the current doctrine that resolves these tensions is called the law enforcement evidentiary privilege. Basically, defense counsel subpoenas police departments, or they might subpoena the private developer of a surveillance software system, or you could imagine maybe it's a face matching system or a voice identification system that if everybody knew how it worked, they could create an adversarial attack that would allow people to evade identification. So they could be subpoenaing the developer or law enforcement, and they're going to say, I need that information for my motion to argue this is unconstitutional or unlawful or inaccurate. Law enforcement's going to say to the court, no, this is a secret law enforcement method that needs to remain secret to be effective. And the court will have to balance those things. So a generalist judge will have to assess whether they believe law enforcement specialists' analysis of how important secrecy is to security. And then if they do believe it, they will have to balance the risks to law enforcement's method against defendants' interests in access. So you may not be surprised to learn that most of these cases, the generalist judge defers to the law enforcement claim. And so most of these cases end up in ongoing secrecy around the law enforcement method. Okay, my final legal doctrine well, let's see, I think I have time. I'll show you these two folks because I think they're kind of interesting and they give some background on this privilege. But okay, so just gives a little bit of a sense of how embedded this power is in our law. But this is a guy named Bishop Atterbury, and he was tried for treason in England in the 17th century. And the law enforcement agency there seized some letters from the mail that were encrypted and then got an expert witness to decrypt them. And lo and behold, the expert witness got up on the witness stand and said, the contents of this letter basically say, hi, I'm Bishop Atterbury and I'm guilty of treason. So let's convict him and sentence him to death. And the defense said, gee, I don't think that was an accurate decryption method. I'd like to contest that. Would you tell me how you did the decryption? And the witness said, no, that's a secret law enforcement investigative method. And if I told you, future criminals would create more robust ciphers and make it harder for us to decrypt. So the court in England, this is a 17th century court in England, says, okay, no problem. We're going to let that witness testify. And we're not going to require disclosure of the methods. And the defense, tough, have a good time trying to cross-examine and impeach. They did eventually convict him. I believe he was initially given some kind of expedition that he could have instead of a death sentence, and then later maybe executed. And the next one, this is a woman named Judith Koplin, and this is the United States. So fast forward, this is the United States at the height of the Cold War, and she was convicted of passing national security secrets to a Soviet spy. Lots and lots of evidence against her. She was definitely guilty of this crime. And the FBI admitted that they had engaged in some illegal wiretapping during the course of the investigation. But they promised, I promise, none of the evidence we introduced at trial was actually the result of this illegal wiretapping. The FBI, the defense wanted access to the FBI's wiretap records, and the FBI actually claimed this privilege to withhold them. Now, the judge in this case upheld the privilege and said, there is this privilege, it does exist, it could apply to these wiretap records. In that particular instance, the FBI had waived the secrecy power for another reason. But this was overall a US late 20th century or mid 20th century endorsement of the same secrecy power that the government in England had used in the 17th century to convict Bishop Atterbury. All right, my last legal doctrine that I wanted to flag for us is contract law. And this is getting a little bit personal because I have been working with some colleagues, Rediat Abebe, Andrea Roth in the law school, to try to access and license an executable copy of a DNA analysis software system that's being used now to convict people at trial. And despite the developer telling courts across the country that this software system is subject to peer review, the developers have refused to provide us with a research license where we could engage in testing and scrutiny of the system. And so companies can use their licensing powers and contract powers to distort who gets access to scrutinized systems or preclude scrutiny altogether. So I think I've got 5 minutes for questions, if that's a thing that we do.
It is indeed. And I don't see any in the chat, but folks in the chat, if you would like to put questions in if you're online, and otherwise I'm going to turn it over to Zach or Ben who are in the room for any questions from the auditorium.
Thanks, Rebecca. That was fascinating. So I have a question about, I suppose, political economy of evidence, especially with the notion of relevance that you were discussing in the beginning, and how that might interact with technical definitions of some legal and ethical terms that are might be of interest to us. So the type of thing that I have in mind is something like fairness, right? in some technical work, it's defined in a very narrow way in terms of the properties of the model. And many people have contested that and said that that's not the right definition. We have to adopt a kind of broader perspective to really see issues of unfairness and discrimination. Depending on which definition we adopt, certain things become relevant or irrelevant as information that pertains to the case.
Mm-hmm.
So do you think these worries are out there and kind of about which definitions win in the technical literature and how that might impact the victims of this type of technologies to actually contest the decisions that are made about them?
Yeah, really interesting issue. So let me start by giving the legal definition of relevance, whichever definition of fairness it ends up going to. So relevance in law is it's a low bar. It narrows things in that you can't go on a totally unbounded fishing expedition to harass or abuse and try to just get access to information just because. It has to be relevant. But what does relevant mean? It means any information that makes a fact at issue more or less likely than it would be without the information. So it doesn't have to prove something. It only has to incrementally make the thing more or less likely. And then this goes to your, that's if you want to cite Federal Rule of Evidence 401. This goes now to the next stage. What's the definition that's at issue? Because it has to be more or less likely than it would be without the evidence, but the fact has to be a fact at issue in the case. And so I think your point about how we define fairness is going to go to what's at issue in the case. And that would be a legal question rather than an evidence question. What's an appropriate system to use? What is a system is sufficiently, say, contestable to satisfy a defendant's confrontation rights or rights to cross-examination? What kind of system is sufficiently unbiased to pass the Equal Protection Clause? And one of the interesting things about having these conversations across CS and law is that it will be courts that finally decide which characteristics of a system matter for the equal protection or constitutional rights analysis. So I think what the technological community can do is present an array of options and argue to courts about which ones they should pick, why they should rely on one or the other, but ultimately will be courts that decide.
This brings me a very fascinating talk. Thank you very much.
Thank you.
This brings me to a question that has been bothering me for quite a while, and that's how technologically savvy are the judges? Do they understand the meaning of statistical evidence? Do they understand the meaning of peer review? Do they understand the meaning of confidence of a prediction? I mean, and is there any way to improve it?
Yeah. Well, this is one of the huge challenges of the legal system as a whole. The short answer is no, they don't understand it. The better answer is that's okay, because generalist judges aren't expected to be experts in any of the things that they rule on. They're not expected to be experts in even the legal areas that they rule on. Rather, they're expected to be educated by the adversary process. So they're expected to learn and inform themselves of complex facts, statistical evidence, by a battle of the experts from both sides. Now, I'm not saying it's a perfect system. I'm sure some of you may have done expert testimony. You know that there's all sorts of problems with it, but that is the system that the legal system has chosen to rely on. So the problem with generalist judges not knowing how to second guess a security expert, how to decide if something's really a national security secret, how to analyze statistical evidence, the way our legal system responds to that problem is to acknowledge it and say our solution is adversarialism. But this gets to another little variation, which is that for secrecy doctrines like the ones I'm talking about, trade secret, privacy, law enforcement, security, secrecy, national security, secrecy, the doctrines themselves rob judges of the benefits of adversarialism because they require judges to make determinations alone in chambers with only the party claiming secrecy present. Otherwise, determining if the secrecy claim is valid would expose the secret in the process of assessing its legitimacy. Okay, so there's this extra complication for adjudicating secrecy claims that are complex. If you have a statistical evidence issue that goes to whether this law enforcement method actually is so sensitive it needs to be secret to be effective, then we're really in trouble. And I don't know what to do about that, but I'm going to say that's the worst of the scenarios.
Rebecca, maybe one last question. In some of your work, you've talked about kind of both the benefit of validation studies, code review, other kind of expert evaluations of systems, but also their limits. And in particular, the ways in which those limits, I think, arise from kind of the ways in which different venues value different sorts of expertise and account for different sorts of evidence, which reflect kind of different value commitments. And I was wondering if you could talk a little bit about that in this context.
Oh, really interesting. Yeah. So there's been, so as an example, what Deirdre's saying, and thank you for the question. You know, for instance, there's a big debate. A lot of defense counsel in different cases have sought source code to scrutinize for computer systems that generate evidence used at trial. And then there's a big debate about whether the source code is necessary to understand how the thing works or validate it or know if it's reliable, whether it's useful, whether it's the most efficient or effective way to assess these things. And so I see a lot of times when defense counsel make motions for source code, people say, oh, they're making a motion for the wrong thing. A better way to go about it, for instance, would be they should be demanding black box validation studies. As Deirdre hinted at, however, there are other values built into the legal process that say defense counsel is the one who should choose how they prove their case. So even if defense counsel's going about asking for something that's maybe not necessary, maybe not even the most efficient or best way of scrutinizing a system, unless there's a darn good reason to block them with a secrecy interest, we have a commitment to letting defense counsel choose how they want to do their job. We don't like the idea of outsiders, experts, certainly not the prosecution, academics, anybody else, telling counsel how to represent their clients. So that's what would be an example, I think, of what you're bringing up, Deirdre. Thank you for the question. Yeah. Thanks to everybody.
Great. I think we're going to end there in part because I think it's a great setup for Alexandra's talk, where we can kind of dig in a little bit more about interpretability as, you know, what kind of value is it? Is it really something that's intrinsic, or is it really something that's instrumental, and who determines? And I think we're moving straight into Alexandra's presentation. Is that right? I can't see.